Welcome, everybody. There are numbers of people still dialing in fast, but we're going to make a start. We intend to give you some time back at the end of the webinar, but we will make a start now, not to waste any more time on this. So we're dealing with this afternoon with what rights do data subjects have under the AI Act, and are they different from the GDPR? And you have three members of us from the International Tech and Data team here at Field Fisher, myself and Thorsten and Johannes. You'll be hearing from each of us. So just first to deal with where we are in our series of webinars and on the AI Act on the next slide. We're at part 3 in our series. Some of you may have dialed into other webinars in this series previously. We've been doing these all year on all of the issues and privacy issues in particular involved with AI and the EU AI Act all year. So we're partway through part 3. On the 26th of September, we dealt with the use of AI in the workplace from permitted to prohibited practices. Today, we're dealing with rights. On the 21st of November, we'll be dealing with AI regulatory enforcement, whether it's the same as GDPR or worse. Then on the next slide, just to indicate in the context of the programme, we have already dealt with part 1, and in part 1 we dealt with debunking the EU AI Act, an overview of the new legal framework, generative AI, privacy risks and challenges, assessing high-risk AI systems under the EU AI Act, and AI governance, what it is and what it should never be. And then part 2 dealt with key contractual consideration for AI system procurement and successful implementation, the DPO and AI officer, are they one and the same, and how to leverage DPIAs for AI risk assessments. So all of these are available on our YouTube channel. You can go and access them, or any one of them if you want to now. And for today's webinar, you will also get a link to the slides and the recording, so you can access all of the topics that have been discussed so far. So an overview of what we're going to deal with today. So the EU AI Act primarily focuses on the obligations regulating AI systems and those with roles in the ecosystem, rather than creating direct rights for individuals. But it does protect the rights of individuals in a number of ways. And in order for us to explain that, we're going to deal with this in the topics that are displayed on this slide. So we're going to talk about the overlap, the interaction between the AI Act and the GDPR. We'll talk specifically about what rights there are under the AI Act. And then to do that, we'll talk in detail about transparency obligations, product liability. We'll summarize at the end the takeaways, so the operational actions that will be needed to make sure you're meeting the obligations for rights under the Act. And we will have time for questions. Please use the chat if you have some questions that you'd like to raise. We should have time to deal with questions. We'll probably deal with them at the end, unless there's anything obvious to deal with as we go along. If we don't manage to answer your question, we will follow up afterwards and make sure that you get an answer. Now I'm going to hand over to Thorsten, who's going to deal with the overlap between the AI Act and the GDPR.
Thank you, Sarah. And thanks everybody for tuning in live or listening later on YouTube to the recording. So as Sarah said, we want to draw some lines here, have some conclusions on where maybe there are some similarities and where the differences lie between the GDPR that we all know, I presume everybody in the audience, and now the AI Act. This is a brief recap. Don't worry, I'm not going through everything again. You will have read up and listened to, just so we get into the groove here. And on the right-hand side, I hope you can see this, there's a bit of an emphasis, because today, sorry for being the spoiler here, we'll be discussing about rights and, for instance, Articles 26 and 50. And these have to do with the annexes, that you'll be familiar with, that Article 6 of the AI Act links to. So these will be important, and I presume you'll have made up your mind to some extent on the annexes, whether the AI Act may apply to you. And this is the timeline. So you probably do have time on many things, but you'll probably have to use that time. It will be necessary, very likely, if you really work on products or have to assess your vendors' products in the AI space. So this is an attempt at pointing out what the commonalities are between the GDPR, let's say, principles, and the AI Act principles insofar as they pertain to individuals' rights. Because there is, in fact, a shared goal between the two, and that's protecting individuals' rights and freedoms. This is at the core of many of these data laws that we're seeing insofar as they pertain to individuals. And this is an overview of where those similarities are, I think. Don't worry, I'm not going to read all those bullets here. You will get the slides. As Sarah said, you can look this up, and you'll probably have the GDPR ones in your head already. And one mechanism, or two mechanisms really, between these two acts at EU level are obligations and rights. This is what the law says. It's not everything, there's a lot more, but these are legal mechanisms how to really make this happen for individuals. You put obligations on, let's say, controllers and processors on the one hand, and then providers and deployers and other ones on the other hand, and also you give individuals rights. Maybe it's worth familiarizing yourself with these. Not now, like I said, we'll go to the next bit, but you will be able to leverage what you've done in GDPR compliance is what I want to give you, maybe as a bit of consolation. But then there's this quite different angle, and this is at the origin of the AI Act, because the AI Act is a product safety law, and we'll pick this up again later. You might recall the slide with the overview of today's content, and you might have wondered, you're a privacy professional perhaps, and maybe you wondered, what do I have to do with product liability? But you can't think the AI Act without thinking about product safety and product liability, because as an outcome, the AI Act has very, very limited direct rights for individuals. The GDPR has strong rights. You can take action, like it says here. You can file for access or deletion, all the other rights under GDPR, you yourself individually. And this is quite different in the AI Act. It focuses more on the products, the AI systems, and the processes that you must have in place and documentation. These are obligations, as I said, on these stakeholders. It's a bit of a shift in focus, really. And this is also reflected in AI Act enforcement, because compliance is largely overseen by authorities, and individuals don't have, I would argue, the exact same strong rights as under GDPR, access and deletion. They do have rights, but it's slightly more indirect or passive. Yeah, you will usually have to complain to a regulator, at least under the AI Act, because another thing that's going to be important for your compliance and everything else around your governance. I think this is pretty obvious, but it may be worth recounting that GDPR also applies to AI systems and so far as they process personal data, like to everything else that involves personal data in Europe. So it's not either or. You'll have to implement the same kind of compliance and have the same governance structure and tick off all the same GDPR requirements that you're used to when it comes to personal data and connection with the AI Act and the AI systems. Which also means, this is now the second bar here on the slide in blue, you will have to be able to respond to data subject rights requests insofar as personal data is part of your AI systems. And as a counterpart to that, the AI Act regulates AI systems, and it doesn't care whether there's personal data in them or not. It just governs them whole, comprehensively, and also imposes those obligations and gives individuals some rights, irrespective of what kind of data is in there. which means as an outcome, there's this overlap of GDPR and AI Act, and some more that I'm going to list in a moment. So it's going to have to be a comprehensive exercise. This just adds more obligations. All of this here and many of the other EU data acts mean job security for lawyers and privacy professionals and similar compliance obligations and functions, but a severe headache for everybody else. You'll have to do comprehensive fact gathering and comprehensive legal assessments in your role. Like I said, there's lots more. One that is specifically called out in Article 87 of the AI Act is the Whistleblower Protection Directive. So if someone reports infringements of the AI Act, they will also be under protection under the Whistleblower Protection Directive, or rather member states' implementations insofar as they apply. And this is also true for many, many, many other laws, everything that's generally applicable, from consumer protection and data protection, as we've seen, via sector-specific legislation, and everything else in general, civil law, common law, depending on your jurisdiction, administrative proceedings, potential criminal sanctions, endless list. Which, as an interim conclusion here for this bit, a comparison with the GDPR and other laws means, at the very, very least, you're dealing with lots of complexity. Nothing is impossible, and you'll have to work and strive towards compliance. But it's severely complex, and you'll have to make strategic decisions. It's a big challenge for everybody out there. And with this, going over to the actual rights, and Johannes.
Thank you very much, Thorsten. Yes, I'm going to talk to you about the data subject rights under the AI Act. And as you can see, we put the data subject in brackets here on the previous slide, because the AI Act does not refer to data subjects unless it's referring to data protection. Instead, the AI Act calls them affected persons or natural or legal persons, which shows what Thorsten just said, that the focus is not on the individual in this case. So I'm going to give you an overview over the actual rights of individuals under the AI Act. And as Thorsten said, there are not that many direct rights for individuals in the AI Act. A little bit hidden in Chapter 9 about post-market monitoring, there is this Section 4 about remedies from individuals. And there are only 3. So the right to lodge a complaint, the right of explanation of individual decision-making, and the right to whistleblowing. We already covered the whistleblowing. It's not a standalone right in the AI Act, but it makes reference to the whistleblowing directive. So let's take a closer look at the other 2. Next slide, please. The right to lodge a complaint with the relevant market surveillance authority. So on the first glance, it looks familiar to data protection specialists, but there are some important differences to the right under the GDPR. The scope is broader. Everybody can lodge a complaint. It can be a human or a company. And it's enough if they have grounds to consider a violation to the AI Act. So no personal involvement is needed in this case. So what would be interesting in practice is how will the market surveillance authorities handle these complaints? So because there could be quite a lot of them. So we'll have to see how the different authorities in the member states will deal with these complaints. Let's take a look at the right to explanation on the next slide, please. So this one only applies to deployers of high-risk systems, which are listed in Annex 3. And there is also an exception for critical infrastructure. The reference to Annex 3 means that it only applies to high-risk AI systems, or it does not apply to the high-risk AI systems, which are a safety component of a product, or the AI system itself is a product that is covered by some union harmonization legislation. If a deployer of a high-risk AI system takes a decision based on the output from the AI system, the affected person can ask for an explanation, but only if the decision produces a legal effect or similar significant effects, and the affected person believes that this has an impact on their health, safety, or fundamental rights. What does the deployer has to provide in this case? There are two things. One, an explanation of the role of the AI system in the decision-making process and the main elements of the decision-taking. And as always, the explanation has to be clear and meaningful. So let's take a little bit, let's dive into this a little bit more closely on the next slide, please. When we look at this closely, we see that there are similarities with the right to be informed about automated decision-making in the GDPR. So remember, in Article 22 GDPR, there is the right not to be subject to a decision based solely on automated decision-making. But there are exceptions to this, and if they apply, you may use this automated decision. However, you still need to inform the data subject in detail about the processing. So let's take a look at the scope here. The scope looks familiar in both laws, but when we look more closely, we spot differences. So regarding the influence of the AI system, the AI Act is a little broader, but narrower when it comes to the effects. It's enough if the decision is based mainly upon AI output, whereas in the GDPR, the decision needs to be solely on automated decision. But on the other hand, the effects need to have an adverse impact on the health, safety, or fundamental rights, whereas in the GDPR, it's enough if the decision produces legal effects or similar. So it's important under the AI Act, it's enough if the affected person considers the adverse impact. So it's interesting to see if they need to provide any evidence for this adverse impact. So in practice, it could be a strategy for deployers to ask for this adverse impact from subjects who want to have an explanation. So let's take a look at the information that you have to provide on the next slide. Thank you. Again, we see when we put this one by one, the information to provide under the AI Act and the information to be provided under GDPR for automated decision-making. So for the AI systems, the deployers need to explain the role of the AI system and the main elements of the decision. In the GDPR, it's the logic involved in the decision-making, which is quite similar, but also they have to explain the consequences of the decision to the data subjects. And here's the difference in the direction. So the AI Act says, please explain the process, whereas the GDPR says, explain what this means for the data subject. But when we look at this in the practice, in the end, it will often be part of the same explanation, which means if you are deploying a high-risk AI system that processes personal data, you need to be prepared to answer both questions, and you will probably do this in one explanation. So let's take a quick look at some exceptions on the next slide, please. Well, first, there can be exceptions by union or national law. And the right to explanation only applies to the extent that it is not otherwise covered by this law, by union law. And this again brings us again to the transparency obligation and access rights in the data protection, in data protection, especially in GDPR. So if personal data is involved, first look in the GDPR. That's all for this right. I will now hand over to Sarah to explain us transparency obligations.
Thank you, Johannes. So Johannes has explained to you some of the direct rights that are clear within the EU AI Act. But the Act generally is designed to protect the fundamental rights of individuals in a number of ways, in the way it's designed and the way it's used. So there are some indirect ways in which rights of individuals are protected, and I'm going to deal with some of these now. So as I was just explaining, these are effectively indirect rights. So they're obligations on entities within the supply chain effectively, and so not directly enforceable by individuals, but their intention, the aim of them, is to directly help or serve the individuals to protect their rights. They're actionable indirectly, effectively, by the individual by lodging a complaint with regulators. I'm just mentioning here some other indirect ways that rights are protected that were mentioned by Thorsten earlier. I'm not going to go into more detail of these because these are very indirect, but the purpose of these is also to protect rights of individuals. So you probably will have heard or go back to them if you'd like to hear about the prohibition of harmful AI, which is designed to protect individuals from harm. And you may have heard, if you listen to our high-risk AI system webinar, about fundamental rights impact assessments, which are solely about the whole purpose really is to assess and mitigate the potential impacts on individuals' fundamental rights. But they're very indirect. I'm not going to deal with them any further today. So going on further to deal with transparency obligations, it's worth pausing here just to talk about the roles under the AI Act. So we've mentioned a couple of these terms already in this webinar, but it's really important from now on that we're clear about some of these roles. Excuse me. So we have 4 roles on the slide, which are the 4 main roles that might be mentioned. We're mainly going to deal with providers and deployers here. So when we're talking about providers, we're talking about an entity that develops or has developed for it an AI system or general purpose AI model and places it on the EU market, or it puts the AI system into service under its own name. Deployers are those who use the AI systems. And for providers and deployers, this is summarized very generally, but very generally, they have a place of establishment in the EU, or they're located outside the EU, where the output produced by the AI system is used in the EU. So that's what we're talking about when we talk about providers or deployers. You will also hear reference to importers. They make AI systems from third countries available on the EU market. And distributors are those other than providers or importers in the chain that make AI systems available. So those are the roles I will be referring to within the rest of the slides. So transparency obligations generally. You can see why I referred to the roles now, because these transparency obligations, although very wide ranging, they are different depending on what role you have in the system. So we've indicated on the slide generally that there are obligations for providers and obligations for deployers. And again, these are indirect. They're obligations on the individuals in the system that indirectly create rights or protect rights of individuals. So I'm going to deal with the transparency obligations for providers, and then Johannes is going to deal with the transparency obligations for deployers afterwards. So we have the interaction with AI systems first for providers, and again, to refer back to the roles, provided are those who sorry, Thorsten, next slide is fine. Providers are those who develop or have developed a system and place it on the market, or they put the system into service under their own name. That's what we're talking about here, obligations for providers. So this obligation is applicable to AI systems that have interactions directly with individuals. What is the obligation? The obligation is to design and develop the AI system so that natural persons concerned know that they're interacting with an AI system. They're told or they would know. The exception where you don't actually have to do anything as a provider is if it would be obvious to the individual, an individual who's reasonably well informed, observant and circumspect, take into account the circumstances and context. So if it would be obvious, you don't need to do anything. Otherwise, you may need to take action, and you can see that this obligation it applies right from the beginning. It's in the design stage. It's baking it into the system effectively. There is another exception where for AI systems that are authorized by law to prosecute, also investigate criminal offences with subject to safeguards that protect individuals' rights, and provided they're not used by the public to report offences. So that's the first indirect rights that are protected by obligations of a provider. So the next one then is in relation to the labelling of synthetic content. Again, we're talking about providers, so those who develop or have developed the system, put it on the market, or they put it into use under their own name. This is applicable to an AI system that generates synthetic content. And when we're talking about synthetic content here, obviously it's audio, image, video, or text content. And the obligation here is to make sure that that synthetic content, the output, is in a machine readable format and detectable that it has been artificially generated or manipulated. So you shouldn't be fooled effectively that this isn't, that this is artificially generated. The exception, bit of a technical exception, it doesn't apply to AI systems that perform an assistive function for standard editing or do not substantially alter the input data provided by the deployer or the semantics thereof, or again, where the system is authorized by law to prosecute criminal offences. So those are the two obligations on providers that effectively provide indirect rights or protect rights of individuals. And now Johannes is going to deal with these indirect rights where there are obligations on deployers.
Exactly. Thank you, Sarah. So I'm going to continue with the general provisions applicable to all AI systems when it comes to deployers. And afterwards, I take a quick look at the high-risk provisions. So let's start with this first one here about emotion recognition and biometric categorization systems. You may ask, where could this be relevant? I can give you some examples. So think of a call center or customer support. So you could have an interest in seeing if a customer is happy or if your service staff get angry during the service, during a call or in a ticketing system. Also, you can think of marketing. So how satisfied is the target of an advertisement? Or you can think of the automotive sector, where you want to see how well is the driver of a car, are they tired, are there any risks because they are not aware of the road. So these could be something that fall into the scope of emotion recognition. What is not in scope are systems for criminal prosecution, as also in the other transparency obligations for deployers. What do you have to do if you are a deployer of such a system? Well, in the end, it's pretty simple. You have to inform about the operation of the system. So you have to make the individual aware that an AI system is running and it is covering or it is detecting emotions. In many cases, these will also involve maybe in all cases, this will involve the processing of personal data. So again, you will see this, this will often also be covered in part or even whole by the GDPR transparency. What comes on top is that you have to explicitly inform about the AI function here. So let's take a look at the next one on the next slide, please. That's the one about deep fakes. So the scope is not every generated audio, video, or picture, but it's covered if it looks or sounds like an existing person, a place, an object, or an event. So you are faking that this is a real thing, a real person, a real place, or something else. What do you have to do in this case? Well, you have to show that this content was created with AI. And there is an important exception to this for artists and creative people. It's okay to show and at an appropriate place that does not disturb the display of the work. So you can place this information somewhere where it's not too obvious. It's not entirely clear what this means. It could be that you could add it, for example, to the credits of a song or a video. But the AI office will prepare codes of practices for this, and it's supposed to be here until May 2025. And the EU Commission can adopt them with delegated acts. So hopefully in the future, we will have some more guidance on the specificalities of the information to provide. Let's go on to the next slide, please. This one is quite similar. It's about text generation for publishing. Well, basically, this means AI-generated news. So again, if you are using those systems to generate news, you have to be transparent and indicate that the text you are just presenting was AI generated. There is also one important exception because, and this one is if you have human control and also on top editorial responsibility, you can waive this information. This means that you could use AI assistance in text production. That's okay. And you don't have to be transparent about it. If you have the human control, so you have to it's not sure that you have to edit it in the end. You just have to take responsibility, and a human has to look over the text and say, okay, that's fine. I saw it, and it's in a kind from me. So let's take a look at the transparency obligations for high-risk AI tools on the next slide, please. So the scope here is high-risk AI systems according to Annex 3 again. In this case, only those that make a decision or assist in making a decision related to natural persons. What you have to do in this case, you have to inform the person about the use of the AI tool. Again, it's important to mention that like the other one before, this will always also be subject to GDPR transparency because you are dealing with personal data. And again, the thing that comes on top here is that you have to explicitly tell about the AI use. So all in all, this obligation is not too surprising. Let's take a look at a more specific obligation for employers. This obligation is pretty much the same, but it is specific to the workplace. The only thing that is different is that you also have to specifically inform the workers' representative, which means in most cases the Works Council, and specifications through national labor laws are possible here. Again, this one is also not surprising when you're dealing with high-risk AI systems. This obligation would probably always also arise from national labor law provisions. So that's all from me. I will hand over again to Thorsten to tell us something about product liability.
Excellent. Thanks, Johannes. All right, this is going to be an overview. It's a bit of an outlier, like I indicated in the beginning, or you might have thought when you saw the overview of content today. I'm going to try to have a bit of a ride through an overview of product liability in connection with the AI Act and a bit more generally. The next few slides, it may be a bit much. We're not going to read everything on them. There's a bit of text there where I had to cite the law. Feel free to take a look later on in the recording and when you get the slides. But I will try to give you that overview, what the angle of product safety and product liability is that you have to keep in mind when working with the AI Act. An interesting point I've thought when giving it a bit of thought is that yes, the AI Act is product safety law, but it doesn't have its own liability rules. No, this is something you might have expected thinking about it, but it doesn't. But there's a reason for it, and I'm going into that. The first bullet here is an attempt at explaining or excusing why we're discussing product safety and liability at all. The point, the similarity I want to draw here is that individuals have claims. They can claim compensation or to remedy defects in products or AI systems. That's the individual angle again. That's why it's a right. If you can claim compensation or remedies, that's a right for individuals. And these defects can be costly, obviously. Depending on which sector you work in, you'll have countless examples in your head now of where these costs and liabilities may lie. Because there's the term here, strict liability. I'm going to pick this up again further down. So culpability may not be a point. Causality, yes, but culpability is not a necessary requirement. That's one of the beauties, if you want to take that perspective, of product liability law. Then the AI Act expressly refers to existing law. That's the European Product Liability Directive from 1985. So it's all that has been transposed to member state law. And this is where the actual claims play out in member states under their civil law regimes and in their courts, civil courts. This is important to keep in mind. This is not an EU mechanism because this is not harmonized, essentially. This plays out in the member states. You will have to keep in mind, and I bet you already have, if you're affected, sector-specific regulations. No? Again, more work for lawyers. Everything is complex. You have to try to harmonize everything to have a coherent overview of all the laws applicable. And you will be familiar with those. And on the next slide, I'm going to repeat this theme. There are, on the bottom here, two commercial angles, operational and risk angles. The one is that customers might use alleged defects in the AI components of a product to argue they don't have to pay for your service, or they might actually cancel the whole contract. This is the very same as in any product, or software development phase. It doesn't compare to the term sheet, so the customer's not paying. You'll be familiar with this, or your colleagues in the legal department. The last bit here is, I would argue you have to factor in this product liability in your broader strategy. At the very least, at some point, the CFO or someone else will want to be briefed on what the additional risk is to the company. How do you hedge this risk from a financial perspective? If you've been following our series, this was part of the first leg of our AI webinar series. I copied this over just to give you an idea, again, if you've seen this before, that under Annex I, there's this harmonization legislation. It's separated out into sections, but in the end, it's all applicable, Section A and Section B. The idea is, if you look at these areas of law, sector-specific legislation is, if products in your sector can harm humans, then there will be additional, or very likely be additional sector-specific rules on these, potentially including more rules on liability. And again, you or a colleague internally in the organization will be familiar with these. So this is not something new for once. One of the next bigger questions is going to be, and I indicated this on the earlier slide, is, so what does trigger my liability? And that's the defect. That's the legal term in the old Product Liability Directive. So the idea is, if something doesn't meet the expectations, reasonable expectations, that is, of the person using the product, you might be liable for this defect in the product. And the chain at the bottom goes, the idea, the connection to the AI Act. If you violate the AI Act, maybe that's a lack in safety that your customers, the users of the AI product, have used. It doesn't meet their reasonable expectations, and you'll have to conduct that test above, letters A, B, C. So this might actually be a defect as well under the Product Liability Directive, or to be more precise, on the member states' implementations, their national product liability laws. And then at the end, this may mean that your customer, the user, has a claim for damages against the producer. So another question is, are you the producer? Or are you in the distribution chain? This slide and the next one, those are going to be the last here in this outlier session on liability for products. This one shows you, I know it's a lot of text, but we'll have to look at the text actually, because the old product liability directive does define products, and they refer to movables, even when they're part of immovables, plus electricity. And there's been a decades-old debate on whether this might cover things like software in the past, non-tangibles. From the letter of the law, maybe not, but there are other legal views there. It's a dispute, and there's case law on this, but different ones in the member states. Now, the interesting bit, as I've cited before, is recital 9 of the AI Act expressly referring to the Product Liability Directive. How does this work? You know, if by the letter of the law it doesn't refer to maybe not even AI products in 1985, but software or something else, algorithms. It just refers to the PLD. And now together with the next point, this is beginning to make sense, perhaps, because an overhaul is in the working, and it's imminent actually, because the EU has overhauled the Product Liability Directive. It has been adopted by the Council and needs publishing in the official journal. And then we have a new definition at the bottom part here. And the draft was Article 4, paragraph 1, sentence 2 of the new Product Liability Directive. And this, as you'll see below, highlighted in yellow, expressly included software. We'll have to see what the official journal says in the end, but expect software to be in there. So non-tangible product. And two other important points, I've mentioned them earlier. One is strict liability I've mentioned, and the other one is a presumption of defectiveness in certain cases, which means you might be, or your product might be presumed defective if you haven't followed certain rules. You can disprove this, but that can be difficult to achieve. And the last bit on this liability piece here is there's also, again, more job security for lawyers. There's also going to be another directive, not a regulation like the AI Act, but a directive to be transposed in member state law, which will more specifically deal with product liability in connection with AI systems, more laws. This will take years, very likely. It's in relatively early draft status. It's from 2022, but still it's awaiting Commission approval at the Parliament level. Well, I think we'll see this at some point, but then it also has to be transposed into member state law, like I said. So this is likely going to take years before it's actually applicable, which means at the very bottom here, at the moment, you'll have to deal with the potentially familiar product safety and product liability law under member states' regulations. And Sarah, would you like to take us through a couple of points for everybody to take away?
Yes, thank you, Thorsten. That would be great. We will have time to deal with questions, but I will just summarize before we do that. So this is designed to be a summary of the operational issues that you'll need to think about to meet your obligations that effectively give rights, or either directly or indirectly, or protect rights of individuals. And to start with, I think you will have heard this on other webinars dealing with this issue, that the starting point is determining your role under the AI Act effectively. I went through that slide with you of the key roles. You could see that then some of the key obligations that followed depended on which of those roles you had effectively. So that inevitably is your starting point. And then linked closely with that is classifying the actual system involved. obligations and things that are needed to be done follow on from whether the system is classified as high risk or other classifications under the Act. So that is a key step. Once you've taken those 2 steps, you're effectively then determining your own legal obligations under the legislation. For example, I took you through transparency, fairly broad application, but different depending on roles and classification, etc. So it's a step-by-step process to determine where you are and what you need to do. Clearly, as Thorsten indicated, there will be other laws that are relevant. So you're going to have to determine that relationship with other laws, determine where you sit in a sector-specific regulatory regime. We've talked about the overlap with privacy and the implications of that. There'll be consumer protection law, employment law, etc. So you won't be looking at your AI system just under the AI Act. You will need to look at it much more broadly to make sure that you're compliant and, for the purposes of today's webinar, protecting individuals' rights effectively. Clearly, where there are other laws and other regimes involved, that means that potentially there'll be other regulators. So you'll need to look at what regulators you've got for your AI system and its compliance. So that will be under the AI Act, but it'll also be under data protection laws, competition laws, consumer protection. And we mentioned that it may be all sorts of different kinds of organizations depending on jurisdictional requirements and how it's been determined in countries that you're involved with. So that will need to be assessed. Then you finally get to implementation. Implementing your obligations to protect, rights and responding to those rights being exercised, for example, via transparency and business processes. And again, bearing in mind GDPR principles, we talked about the overlap, accountability, so legitimate interest assessment, data protection impact assessments, notices, data subject rights handling, and I referred to fundamental rights impact assessments, particularly under the EU AI Act, which is all about assessing and mitigating the potential impacts on individuals' rights. Thorsten just mentioned, and we think it's important that this isn't overlooked, that there will be financial implications of this, and that should be assessed. So that might be through liability or just the operational resources that are going to be needed. And I think also it's worth emphasising that clearly a lot of this needs to be thought about from the outset. A lot of this is to be baked in to the system from the beginning. It's not something that you can just do at the end, roll out a system and then at the end think, oh gosh, yes, how do we deal with individuals wanting to exercise their rights? It doesn't work that way with AI systems. The AI Act very much is focused on the system itself rather than the individuals. So just before we deal with any questions, if we just go through to the next slide and onwards, Thorsten, and the next one, that's it, thank you. Sorry, go back to the previous one. That's it. Thank you. Just to indicate before we deal with questions, where you might get other resources on this. Obviously, contact us if you have any questions beyond this. But we have an AI regulatory guidebook that you can access. You'll have links to it when you get the materials. We have a web page that gives you information about all our webinars and other sources of support and the practice generally. We have a privacy blog. And as we've mentioned, we have the YouTube channel, which has lots of free training, webinars, and the whole series of the AR webinars. And next slide then, Thorsten. Thank you. Gives the contact details. As I mentioned, myself, Thorsten, and Johannes have been dealing with the webinar today. So we have time to deal with a couple of questions. First one, if I mention just the first one, somebody's asked about talking about the overlap of GDPR and the EU AI Act, the extent to which you can use processes and policies and expenditure that you've already laid out in compliance with the EU AI Act and dealing with data subject rights. And I'm sure Thorsten and Johannes will have some views on this, but I thought I'd dive in first to say that hopefully we've demonstrated today that although there is overlap, actually when you're talking about rights, it's very different actually from GDPR to the EU AI Act. As we indicated, the GDPR is very much focused on the individual and their rights, whereas the EU AI Act is focused really on the system, albeit that it is supposed to protect individuals' rights in a number of ways. But when you think about the rights that we've taken you through today, so we talked about, Johannes talked about the direct rights, and then we both talked about those individual indirect rights. They are very different from the rights that might be exercised under GDPR. So actually the extent to which your processes that you've got in place to respond to individuals exercising their rights under the GDPR, so their right of access, their right to object, for example, it probably of limited use when you're complying with your transparency obligations to give information about, you know, that it is AI or that the output is artificial is very different, and so probably not being able to utilize an awful lot of systems that you have in place already under GDPR for this aspect of compliance under the EU AI Act. And I don't know if Thorsten or Johannes have anything else to add there, but
I think you've covered it, Sarah. So maybe to reiterate what we said above, I'm often a DPO for clients or working with DPOs, CISOs, and I would simply expect that it's, at least in the beginning, more or less the same exercise as someone or responding to someone executing the data subject rights under the GDPR, because the facts you need from applications from the company's infrastructure and network and everything, and maybe business units, I would expect to be quite similar. You may not need all the business units and not all the applications, because not all of them are AI systems, but for those that are AI systems, I think it might look quite similar. The other thought I had was it has taken a bit of time, a couple of years under the GDPR, once it became applicable for DSRs, data subject rights, to be exercised more broadly. There were first few waves, maybe smaller ones for some companies, some large brands, but then for this to arrive and, let's say, employment or post-employment disputes and people sending all those emails, it took a bit of time. And I'm sometimes wondering, I don't have the answer because this lies in the future, but I'm wondering whether we might see something where the data subject rights template that is sent then also might refer expressly to the AI Act and transparency obligations. But we don't know. But if we will, I think this is also going to take a bit of time.
yes, and I don't think it's all bad news for work that's already been done under GDPR, and I think we've probably mentioned this in other webinars. So for other aspects of for compliance under the AI Act, you will be able to reuse processes and systems and policies that you have in place. So when you're putting in place your whole governance framework, or for risk assessments that have to be done, there will be work, there will be information and processes and things you have in place that will be relevant. So it hasn't all got to be created from scratch effectively.
Just to add one thought, if you're thinking about what changes through the use of AI to data subject rights in general, I think one important thing that comes on top is the topic of explainability. So you have to prepare all the information that you would have to prepare under the GDPR. This is just business as usual. But what comes on top is that you have to explain in more detail how the AI system works and how the AI system is dealing with personal data. So it has a technical perspective that comes into scope here.
Thank you, Johannes. looking at the list of questions, I'm conscious that I said we would give time back at the end, and I do like to do that. I don't like to run straight up to the hour. I think we have some questions that we will follow up with directly to the individuals. We'll make sure you get an answer. And if anyone has any other questions they'd like to raise, feel free to contact any of us. So we'll say goodbye and thank you very much for attending.
Thank you, everyone.
Thank you.